The state told a story of rage and vengeance. I don't believe the court bought into that because I think that the court saw it more as fear that was motivating Mr. Dodson, not rage. But there were still some comments that kind of just didn't fit, but set the table for this discussion about, is this happening because we have more guns in our community? Is this happening because we're letting people have concealed carry permits? The state said we cannot just look the other way and chalk this kind of carnage up to our CCW laws or our self-defense laws or our castle doctrines or whatever we've got these days that are condoning deadly force. There's still such a thing as too much. That's the context in which the court said, on this day, you set this in motion when you chose to go out and purchase a firearm, go out and be armed. So I think that that's sort of what set the table for it.
The state's position is as follows. First, Judge Donald's reference to the comments that are the focus of this appeal do not in and of itself reflect an improper factor. And reading the sentencing transcript as a whole and in context, which is what all of the cases, Alexander, Williams, and so on, require reviewing courts to do, it's not the case where Judge Donald's sentence was based on that. A careful reading of his comments when read in as a whole reflect that he was focused on the seriousness of the offense, but also spent a fair amount of time acknowledging the mitigating factors, the positives about Mr. Dodson, his crime-free background, the fact that he was working, the fact that he was supporting a family. So this is not a case where the court wanted to send a message